कैसे करेंगे?
हेलो।
हाँ, अब आवाज आ रही है, अब आ रही है, आवाज आ रही है, प्लीज।
मेरे मोबाइल जस्ट अ मिनट सर।
हाँ, अब आपकी आवाज आ रही है।
Sir, on behalf of GIPA and YAPA, first of all, welcome all of you, especially Manoj Kumar Anand ji and Dr. Tripti Rathi and our guest of speaker, Advocate Hani Satpal ji. Welcome, Dr. Tripti Rathi ji. And
Good afternoon, sir. Good afternoon, Manoj sir.
Afternoon.
Thank you, sir.
Explaining JIPA and YAPA and myself, I am just brief about our first speaker, Mr. Manoj Anand ji. Mr. Manoj Anand ji, 60 years CA and IP and director with insolvency professional entity. He is IP since 7 years and chartered accountant more than 30 years experience, sir. He is handling total 14 PG to CD assignments and more than 24 CIP of liquidation assignments under IBC. And is doing a CA practice as audit and income tax cases up to ITAT level mainly for corporates. And he has also academics in article writing published in national newspapers and Pioneer and Insolvency Professional. Also delivered lectures at Singapore in an international conventions on IBC. Wrote 2 books on insolvency. Number 1, Practical Guide on Valuation and Legal Framework in India. And second one is Enterprise Management at CD by RP. And number 3, visiting faculty at various seminars held by ICI, ICSI, IB, CBI, etc. And founder president YAPA, special inviting member to various committees, running YouTube channels, IBC, IP Creatives. I once again thanks to our IP Manoj Anand. Please share your valuable experience to our participants. Please, sir.
Oh, no, thank you. When our, my co-speaker, Dr. Tripti Rathi and Advocate Hani Satpal is there, I should confine myself to the low profile only. Okay, in any case, as a formal vote of welcome, I, on behalf of whole IP community, welcome our, I understand Dr. Tripti is a teacher, our teacher, speaker, assistant professor, Symbiosis Law School, Pune, along with Advocate Hani Satpal from HS Legal. Dr. Tripti shall enlighten us on IM Information Memorandum, EOI, EM, RFRP, request for registration plan under Section 29, read with CRIP Regulation 35 to 38. Since resolution is a main objective of IBC, and in that process, IBC asks registrars to sacrifice their huge money. But this sacrifice or haircut can be reduced substantially by bringing in high quality resolution plan. The order to bring a high quality registration plan is in the preparation of information memorandum, expression of interest, evaluation metrics, and RFRP. In my practical experience, I've seen these documents doesn't sound very strong, but practically these are very, very strong documents, especially evaluation metrics and other things. Hopefully, we IPs all shall become more wiser after listening to Dr. Tripati today and shall contribute more to IBC 2016. I welcome again to Dr. Tripati. Okay, I also welcome our young advocate Hani Satpal from HS Legal for her deliberation on the recent judgments. Honorable Supreme Court has not only settled a lot of many issues, but also had given birth to a few new issues also. I remember adjudication by Honorable Supreme Court Judge Indira Banerjee in the famous Rainbow and Vidarbha cases, whereas the concept of secured creditor in case of government dues and consideration of liquidity for Section 7 application was given 360-degree turn, overriding IBC objective. Lately, I have also found many a time that NCLAT judgments have been given 360-degree turn by our Honorable Supreme Court. I remember in this regard, Greater Noida Authority judgment, Bharti Airtel, Paschimanaanchal Vidyut Vitran Nigam, visually our advocate Hani will enlighten us the logic behind all this 360 or 180-degree turn. Welcome, Advocate Hani Satpalji. Okay, I'm also one of the co-speaker there. So my topic is PG to CD. Yeah, basically PG2CD is younger brother of CIP, but lately it has gained a lot of prominence, especially after Dilip V. Javrajika judgment in November 2023 by the Honorable Supreme Court. After that, all NCLT benches are acting very fast, adjudicating all pending cases which were put on hold till this particular judgment of Dilip B. Javrajika judgment. It is a vast topic. RPs are facing many problems in handling all these cases because there is no written stuff available to handle practical issues therein. Today, I shall raise curtain on problems and possible solutions as per my wisdom, and shall take full session after the 2 weeks, as on 8th of June 2024 at the same time 4 p.m. Please bear with us, and let us now start my PPT up with this topic. My co-host, allow me to start my PPT.
Yes, sir. You are also co-host, sir. You can do very well.
Okay. तो चलिए आई बी टेकिंग अप्रोक्सीमेटली 10 मिनट ऑलरेडी हो गए हैं तो सिंस आई एम द होस्ट आल्सो I would like to give more respect to my other co-speakers, and shall be taking another 20-25 minutes basically dealing with all this thing, and so that more time can be given to my other speakers also. I hope my PPT is now visible. This is a simple vote appeal, I thought of giving on this day.
Yes, sir. Visual.
This is a flyer which we have shared with everybody, and welcoming all our speakers and audience also there. Basically, I will discussing only those technical points which will have effect of PG2CD cases from insolvency professional perspective. I won't be discussing in detail because the time is very short. History of this cases, Lalit Kumar Jain, Javrajika judgment, and other important judgment. Procedural part of CD to PG cases. I be what practically doing this cases, what problems I have faced. I be simply discussing those particular aspects only. So that my basically our objective is to enlighten our IP brothers, so that whatever problem we faced doing initial cases, at least they don't face all those problems while doing cases now. Okay, if we see the market size, everything depends on the market size of the industry. And as far as this particular PG to CD cases are concerned, I've been able to knock 31st March 2024 cases. तो इसके अंदर अभी तक जो टोटल केसेस हुए हैं 2800 केसेस हुए हैं, और इसके अंदर जो अमाउंट इन्वॉल्व है वो है 1.88 लाख करोड़ ऑफ रुपीस. और अगर हम इसमें रिकवरी की बात करें तो it was a very big complaint for CRP cases that recovery there is also very less. But when we see the recovery in the cases of PG to CD, it is only 2.16% as far as IBBI data is concerned. तो इसके अंदर जो हमारी क्या कहते हैं 94 95 की मेन एप्लीकेशंस होती हैं, एंड एवरीबॉडी नोज 94 इज बाय द डेटर एंड 95 बाय द क्रेडिटर. तो मैक्सिमम एप्लीकेशन इसके अंदर 95 में ही आई है, बिकॉज बैंकर्स ने अपने पैसे रिकवर करने के लिए PG to CD केसेस करे हैं. तो दिस इज द इनिशियल स्टार्टअप एंड शेयरिंग विद यू द मार्केट साइज. When we look into the main reasons of this insolvency, PG to CD cases, what I found practically, while handling cases by me as an individual or acting as a consultant for a lot of other IPs. First reason is that as far as Section 94 application is concerned, whatever if any surfacey proceedings are going on against a PG, they immediately file their application under Section 94 so that they can get rid of being not share their assets with the under surfacey with the financial creditor. Another thing I found is that in many cases, if there are huge tax liability, especially because of any people who have indulged in GST and other illegal transactions, they also go filing Section 94 application so that they can get rid of that particular aspect. Business failure during epidemic, especially in hotel and airlines industry, now it is booming a lot, but that has also prompted some of the directors to go for that. Another reason I found is that whenever anybody has defaulted in CRP and he came to know that proceedings are going to be started against him, then he says, instead of RP from the to be pointed from the creditor side, let me file my application under 94 and at least get some relief by appointing my own RP. तो एक ये भी एक एस्पेक्ट है, बिकॉज बैंक्स डू टेक देयर टाइम इन अप्रूवल ऑल दिस इन देयर। तो मैंने एक दो केसेस के अंदर देखा जो मैं हैंडल कर रहा हूँ, तो डेटर ने स्मार्टनेस दिखाई, उसने पहले ही 94 की एप्लीकेशन फाइल कर दी। नेचुरली जो एप्लीकेशन पहले आएगी दैट विल प्रिवेल, अदर्स विल बी केप्ट इन अबायंस। ओके, सेक्शन 95 की एप्लीकेशन का जो सबसे बड़ा रीजन है वो है कि मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स ने इंस्ट्रक्शंस दी ऑल बैंक्स को थ्रू देयर एसोसिएशन की जो है इनकी, कि यू शुड फाइल केसेस अगेंस्ट ऑल द डायरेक्टर्स ऑफ द डिफॉल्टिंग कंपनीज हु आर ऑलरेडी इन द सीआरपी। स्पेशली आप इफ यू रिमेंबर, हमारे यहाँ पे 12 बहुत बड़े केसेस जो होते हैं स्टार्टिंग के अंदर 2017 के अंदर, उनके डायरेक्टर्स के केस। रीजन उसका यह था कि गवर्नमेंट वाज बीइंग हेवीली क्रिटिसाइज्ड कि आप इनकी कंपनीज को तो सीआरपी में ले आए हो, लेकिन इनका जो है इंडिविजुअल डायरेक्टर्स का है, इनके ऊपर तो कोई असर हुआ नहीं, बिकॉज कंपनी के एसेट चले गए, हो गए, दाएं बाएं हो गए, दे आर लिविंग किंग साइज लाइफ। And I won't name it. I shall name it in my when I shall talk in detail. तो कौन कौन से इन बंदों के बारे में उन्होंने कहा, तो फिर उन्होंने तो दे इंस्ट्रक्टेड कि they should move an application against them also. तो इस करके फिर banks were quite prolific and quite fast in filing application there. दूसरा मैंने रीजन ये देखा है कि जैसे सीआरपी के अंदर जनरली कंपनीज के एसेट्स होते हैं, जब हर सीआरपी प्रोसेस के अंदर डायरेक्टर्स ने गारंटी दी होती है, जब डायरेक्टर्स ने गारंटी दी होती है तो उनके पास जनरली जैसे स्पाउसेस हो गई, मेन डायरेक्टर हो गया, प्लीज अपने आप को जरा म्यूट कर लीजिए। प्रवीण जी आप ध्यान दे लेना, जो भी थोड़ा सा वो है तो उसको थोड़ा सा म्यूट कर देना बीच बीच में, ठीक है। तो उनके अगेंस्ट भी ये क्या नाम टू पुट बेसिकली, हाँ मैं ये कह रहा था कि सीआरपी के अंदर जब वो केसेस चल रहे होते हैं तो जब डायरेक्टर्स ने गारंटी दी होती है तो जस्ट टू हैव अ गुड रिकवरी और 12A के अंदर ताकि वो वापसी हो जाए, वो केसेस की सेटलमेंट वगैरह में ओटीएस वगैरह हो जाए, तो उस चक्कर में भी वो दे पुट एन एप्लीकेशन अगेंस्ट directors to put a pressure on them. And in fact, I've seen this practically in my cases also. DD Motors is a very famous, the Maruti dealer in Delhi. So in case CRP start हुई थी तो, लेकिन they were having a more worry when the 95 application was started against the director, because कुछ housewives होती हैं, ladies वो generally directors होती हैं, लेकिन theoretically उनकी भी गारंटी ले ली जाती है। तो that scheme with HDFC Bank was very successful, and they because of that particular pressure, this particular CD entered into 12A application and paid all taxes up to date, all dues up to date, including interest, penalties and everything there. मैंने सोचा कि वो जो रह गया था बाल वाला तो प्रवीण जी जरा पीछे देखना आप प्लीज, मैं एक मिनट स्टॉप करके मैं टैली में मैंने एंट्री कर दिया, प्लस वो बैलेंस शीट वगैरह पूरी बना दी है और डायरेक्ट रिपोर्ट बना दी। प्रवीण जी जरा म्यूट करेंगे आप सबको? ऑडिटर रिपोर्ट या थैंक यू। ड्यू अपॉलॉजी फॉर स्मॉल डिस्टर्बेंस। तो ये मैंने आपके साथ डिस्कस करा, जो मैंने प्रैक्टिकली देखा है कि ये केसेस स्टार्ट होने का रीजन 94, 95 की एप्लीकेशन स्टार्ट होने का रीजन। चलिए अब जब हम लोग वी गेट अपॉइंटेड एज एन आरपी, व्हाट प्रॉब्लम्स वी फाइंड व्हाइल स्टार्टिंग द केसेस, आई एम शेयरिंग दैट विद यू। सबसे बड़ी प्रॉब्लम आती है कि जैसे हमारे यहाँ पे पब्लिक नोटिस फॉर्म ए के अंदर जाता है सीआरपी में, फॉर्म बी के अंदर जाता है लिक्विडेशन में, इसके अंदर भी हमारे को पब्लिक नोटिस विद इन 5 days आई थिंक देना होता है अंडर सेक्शन 102। तो इसका कोई फॉर्मेट ही प्रिस्क्राइब नहीं है। जब इसका कोई फॉर्मेट ही नहीं प्रिस्क्राइब तो आरपीज आर रियली वरीड कि हम किस फॉर्मेट के अंदर इसका पब्लिक नोटिस दें। तो what mistake they do is that they take the format from bank from form E का जो CRP का फॉर्मेट है उसको लेके वो पब्लिक नोटिस दे देते हैं। इन माय ओपिनियन बैंक्रप्सी के अंदर फॉर्म सी का फॉर्मेट दिया गया है, तो यू शुड टेक, दिस इज माय सजेशन, नथिंग मोर देन दैट, you take format from the form C and then file it, put your public notice in the newspaper based on that format for your insolvency cases, insolvency for PG to CD. Okay, duty has been cast on the debtor for preparation of statement of affairs under revision so and so, but no detail is provided by the guarantor. ये एक बड़ी भयंकर प्रॉब्लम है कि हमारे पे ड्यूटी कॉस्ट कर दी है लॉ ने और कोई डिटेल गंटर प्रोवाइड नहीं करता, तो उसमें क्या करें? तो उसमें हम यही कर सकते हैं कि जो हमने इनिशियली फॉर्म ए एंड सी फाइल करा था उसके अंदर जितनी डिटेल है, एंड टू दैट एक्सटेंट यू फाइल द prepare the statement of affairs accordingly. Duty cast on RP for preparation of repayment plan against no details provided by the grantor. This is a repetitive of my above thing. इसके अंदर earlier फाइल रिपोर्ट, बिकॉज एक्चुअली बेसिकली ना ये जो हमारा पीजी टू सीडी का प्रोसेस है, ये प्रोसेस ऐसा है कि पहले एप्लीकेशन हम ये फाइल करते हैं, इंटरम मोरेटोरियम एकदम स्टार्ट हो जाता है, उसके बाद हम सेक्शन 99 की रिपोर्ट फाइल करते हैं, फिर कोर्ट 100 सेक्शन 100 के अंदर इसको ऑर्डर करती है, फिर उसके बाद 102 के अंदर हम ये स्टेटमेंट ऑफ अफेयर्स वगैरह सब कुछ बनाते हैं, फिर 103 वगैरह के अंदर ये रीपेमेंट प्लान वगैरह हम सबमिट करते हैं, तो उसके बाद फिर ये जो 103 104 के अंदर, देन आफ्टर दैट 109 के अंदर कोर्ट ऑर्डर पास करते हो। तो एक सारी चीजें एक दूसरे से लिंक्ड है। जब चीजें लिंक्ड है तो जब हमारे को रिपोर्ट वहां पे फाइल करना जरूरी होता है तो कोई डिटेल मिलती नहीं, तो हम क्या करें? व्हाट सोल्यूशन वी हैव? द सोल्यूशन फॉर दैट इज फाइल रिपोर्ट एंड सो एंड सो, या ओके, ड्यूटी कास्ट एंड सो एंड फाइल जो उसके 104 की आपने रिपोर्ट करनी है, तो उसके अंदर आप सिंपली एक यही रिपोर्ट फाइल कर दीजिए कि मेरे को कोई डिटेल नहीं मिली, वी शुड गो फॉर द क्लोजर ऑफ दिस थिंग। 30/1/2024 तक तो ये क्या कहते हैं क्रेडिटर्स की मीटिंग करना भी जरूरी नहीं था, बट 30/1/24 के बाद उन्होंने अमेंडमेंट ला दी कि आपको क्रेडिटर्स की मीटिंग करना पड़ेगा, तो यू हैव ए क्रेडिटर्स मीटिंग एंड इन्फॉर्म इट देयर। Okay, another problem we face is that no format for reporting to section 99/104 list of creditors and so on is available. ये तो हम लोगों को भी बड़ी मुश्किल हुई जब हम लोगों ने केसेस स्टार्ट करे, तो इसका सोल्यूशन तो सिर्फ यही है, ट्रायल एंड एरर इज द ओनली सोल्यूशन। If anybody gets stuck up, he can knock me. I can also share reports which we have submitted there. A lot of people have already knocked me many a time, and I do share with them. But for that, I request a regulator or agency should come out with a format. So they have the what sources. R is a very small entity and office. So that एक standardized way से इसका हो जाए till the time these are not being specified in the annexure of the particular regulation. Notice time limit 14 days prescribe करिए अंडर द सेक्शन 1077 करिए, रेगुलेशन के अंदर 14 days prescribe करिए। तो इसका सोल्यूशन यही है कि आप पहली एमओसी के अंदर ही जैसे हम सीआरपी के अंदर करते हैं 1 या 2 दिन का आप वो अप्रूवल ले लीजिए एंड अकॉर्डिंगली नोटिस देखना शुरू कर दीजिए। बिकॉज अगर 7 और 14 दिन का कि आप स्टैंडर्ड गाइडलाइंस में जाएंगे तो इसका मतलब ये है कि एक दिन में एक ही मीटिंग कर पाओगे और टोटल इसके अंदर 180 days है केस खत्म करने के लिए। Okay, NCLT benches started asking legal documentation, power of attorney, legally and authorization from applicant director in favor of RP to initiate proceedings under section 94. इसके अंदर we need to be very cautious because we should not obtain any document which should show that we are related to other. But no, earlier, when we started this practice 2 years ago, then benches were quite frantic in asking all this thing. Now they are a little bit relented and accepting the application filed in Form A. From the under section 94 for the debtors. Okay, now मैं थोड़ा सा फास्ट मूव करूंगा बिकॉज स्लाइड्स 8-10 अभी और हैं जो मेरे को करना है। प्री रिक्विजिट फॉर फाइलिंग एप्लीकेशन अंडर सेक्शन 95 बाय द क्रेडिटर, एप्लीकेशन फाइल करना बिकॉज इसके अंदर इंटरम मोरेटोरियम अंडर सेक्शन 100 एकदम स्टार्ट हो जाता है। वी शुड फाइल द एप्लीकेशन इन अ वेरी डिलिजेंट मैनर क्योंकि अदरवाइज इट गेट्स स्टक अप विद द रजिस्ट्री or maybe with the NCLT also. तो इसमें क्या क्या पॉइंट्स है जो हमारे को एप्लीकेशन फाइल करने के लिए देखने हैं, वो ये हैं. वी नीड टू चेक द लिमिटेशन. सेक्शन 13 सबसेक्शन 2 सरफासी एक्ट के अंदर अगर क्या कहते हैं बोरोअर को नोटिस इशू करा गया है, तो दैट वोंट बी एप्लीकेबल एज फार एज आर रिवोकेशन ऑफ गारंटी इज कंसर्न, बिकॉज इट इज अ सेपरेट प्रोसीडिंग एज पर लॉ. We should thoroughly see CRP or NCLT order if it is in place. Bank statement of the CD should be seen. Sanction letter of the the sanction letter of the financial creditor to be seen. Guarantee deed should be seen properly. Balance confirmation should be seen from the angle of limitation. 3 साल के बीच में ही होनी चाहिए, और आपको जो गारंटी है वो भी आपको रिवोक करनी चाहिए विद इन a period of 3 years. Documentary evidence of guarantee eligible is form so and so so and so. तो ये कुछ हम लोगों ने प्रैक्टिकल बने पॉइंट्स बनाए थे, विच पीपीटी आई शैल बी शेयरिंग विद यू. जो यूट्यूब चैनल पे आप लेटर ऑन दे सकते हैं. तो इनका यू टेक अ कॉशन, बिकॉज अगर इनके अंदर कोई कमी होती है तो इसी बेस पे आपकी एप्लीकेशन रिजेक्ट हो जाती है, एंड सारी की सारी आपकी जो मेहनत करी हुई होती है वो खराब हो जाती है. Another thought comes to with the IP is that if no CRP is going on, can proceeding as PG to CD be started? Yes. Section 2 says very clearly. Section 2 subsection E says that he should be PG to CD, and you can do it there. Honorable Supreme Court has interpreted in that way. In fact, Honorable Supreme Court has gone to the extent to saying that even if no CRP is going on, this proceedings can be started. If proceedings are going on a DRT, can petition against him be filed at NCLT where it should be adjudicated? Yes, yes. DRT के अंदर एक डिफरेंट सिचुएशन में पिटिशन फाइल होती है. एनसीएलटी में सिर्फ पीजी टू सीडी के केसेस की ही फाइल होती है. ये ओनली कंडीशन इज कि 2E का जो हमारा है इट शुड बी देयर, और सेक्शन 60 के अकॉर्डिंगली यू कैन रिक्वेस्ट टू द DRT टू ट्रांसफर द केस टू द NCLT also. CRP petitions are going on at different places. Many times it happens that applications under section 7, 9, 10 is filed at different places. Then where the PG to CD shall file his application, either under section 95 or 94. In that case, there's no precedent, but it happened in the earlier CRP cases whereby Videocon case, all the cases are clubbed to the Bombay NCLT. Similarly, I hope something that will also not, but you can file an application with the principal bench for the guidance if you come across any of such situation, whereas CRP proceedings application is filed but not adjudicated till filing of your application. If many applications under section 95 are filed against PG to CD, because you're not aware of it, who have filed a section 95 application against you? For example, a person can be a director in 4 companies, and one company is registered office in Bombay, another in Delhi, and fourth one is in Chennai. In that case, one of the financial creditors have filed an application against him in Delhi. If he has filed an application against him in Delhi, what Bombay and Chennai will do? In that case, what this thing practically happened with me in the case of Intech Capital versus Vipulkant. There were earliest filed in that case, the earliest filed RP application shall be taken care of it, and he shall be appointed as an RP, and rest can file claim against that and keep their petition in abeyance till the acceptance of the earliest petition filed by the RP. Limitation applicably from the date of execution of papers or from the date of revocation? And definitely from the date of revocation as far as contract is concerned. Where to file the application? 2E, where registered office of the company is there. And if you are filing application under IBC, then definitely at NCLT, and otherwise at DRT. Here one situation also comes out to be there. I think I'm covering it in my next question. That is also very important. Can PG recover amount from CD later on the payments made to creditor? This is a very pertinent question, that if, for example, if PG has paid the money, can he recover the money from from the CD later on, or if the company has already gone through the whole CRP process and new promoters are there, can he recover the amount from the new CD or not? Answer for that is, let's understand the basics first. As far as contract is concerned, that under section 145, there is an implied promise to indemnify surety by the borrower for all rightful sums paid under the contract of guarantee. But section 31 of the IBC says approval of the registration plan is absolute and binding on all, including PG to CG. In that case, some split shall not be rightful and PG shall not be entitled to indemnify from the city. मीनिंग देयर बाय कि हमारा जो आईबीसी है 238 के सेक्शन के अकॉर्डिंगली इट एक्सीड्स कॉन्ट्रैक्ट एक्ट। अगर आपने क्या कहते हैं पीजे ने पैसे पे कर दिए हैं और उसका रजिस्ट्रेशन 31 के अंदर ऑलरेडी आ गया है, सेक्शन 31 के अंदर रजिस्ट्रेशन प्लान ऑलरेडी अप्रूव हो गया है, तो इन दैट केस यू मे नॉट बी फॉर यू इट मे नॉट बी पॉसिबल टू रिकवर द मनी एज ए राइट ऑफ सब्रोगेशन। If multiple location, the CRP is going on multi-application or file notes, the PV shall allocate easy. Can same RP be pointed for more than one personal contest gain the same data? Yes. It is convenient and cost effective also, and a trend with banks also. In fact, recently in अभी approximately महीना पहले ये केस आया था SBI versus Mukesh Arena Bansal case, whereas SBI did not give the name and RPO was appointed from the panel. SBI did not give details to the RPI. He filed petition against SBI. NCLT imposed fine of rupees 1 lakh on the SBI, but NCLAT reversed the order and appointed SBI proposed RP under section 98. I reserve my comments on it. I shall talk about it in detail because with due respect to the NCLAT, the interpretation taken by them for section 98 by removing that particular RP perhaps need to be re-looked into. Okay. If a partner director from an IP is RP of the CD, can he be appointed as RP of the personal contract? No, yes, with effect from 31/1/2024. Earlier, no, because explanation 3 to regulation 4C so and so specifically prohibits it. हम लोग ही गलती नहीं करते। आई जस्ट कम अक्रॉस कि हमारे यहाँ पे एक एथेंस का केस बड़ा इंपॉर्टेंट था, उसके अंदर एनसीएलटी बेंच ने आरपी को ही पीजी का और सीडी का आरपी अपॉइंट कर दिया। If a partner director from an IP is RP of CD, can the other partner director be appointed as RP of PG? Yes, because there is no specific exclusion except as per regulation 4, which restricts the appointment that he should not be representing any party in the registration process, meaning thereby PRA or SRA. Application filed with the registry says so and so date, then hearing came out on so and so, first notice by L6 so and so. When interim moratorium will start? Interim moratorium will start immediately on filing. I put this question specifically because some people get confused with the CRP proceeding, where on the acceptance of the application moratorium under section 14 starts, but in the case of PG to CD, it starts immediately filing the application. Default amount rupees 1,000 as per section 88, but application below 1 crore are not accepted by many NCLT benches. Only recourse available to you in that case is to file with a DRT, and because they said that IBC is applicable only when there's a default amount of 1 crore or above. So in that case, you have to file compulsorily application at DRT. That is why you will see that in my initial style, 25 applications has been filed at DRT instead of at NCLT. One more anomaly I found while doing the cases is that there is something wrongly mentioned in the rule book act. That section 113 gives reference to section 99 for decision taken in MOC. In my opinion, it should have been section 112. In any case, I thought of sharing with you. Okay, there has been two very big controversies. One controversy is it is with reference to the replacement of RP under section 98, and another controversy is that can co-borrower act as a PG to CD and file application under section 95. तो ये अभी दो जो इश्यूज हैं ये अभी एडजुडिकेट नहीं हुए, डिस्पाइट जवार्जिका और ललित कुमार जैन एंड अदर केसेस के अंदर बहुत सारे इश्यूज ऑलरेडी एडजुडिकेट हो गए। तो ये इश्यूज में अगर आप कभी फंस जाओ या कभी आपके पास आ जाए तो आई एम एनलाइटनिंग यू कि ये इसके अंदर फॉर एंड अगेंस्ट के अंदर क्या क्या प्रोविजंस है। तो पहले हम इसको थोड़ा सा डीपली देख लेते हैं। पहला जो मैंने लिया है रिप्लेसमेंट ऑफ आरपी अंडर सेक्शन 98। हमारे सीआरपी प्रोसेस के अंदर क्या होता है, 2/3 मेजोरिटी के साथ जब भी सीओसी चाहे आरपी को चेंज कर सकती है, बट दैट सिचुएशन इज नॉट देयर इन द केस ऑफ पीजी टू सीडी केसेस। Why that situation is not there? Let me read it you with the relevant portion of the section. section, here section 98 deals with the replacement of the RP. Section 98 subsection 1 says where the debtor or the creditor is of the opinion that the resident professional appointed at section 97 is required to be replaced, he may apply to the adjudicatory authority for the replacement of such a resolution professional. आपको ये प्लेन इसको पढ़ के ये लगा कि डेटर द क्रेडिटर जब चाहे अपॉइंटेड उसको रिप्लेस कर सकते हैं. अब ये इतना आसान नहीं है. मोस्ट ऑफली देयर इज एम्बिग्युइटी इन द लैंग्वेज. लैंग्वेज इस पे प्रॉपर नहीं लिखेगी. ये इस चीज का हमारे को तब पता चलता है व्हेन वी रीड द सबसेक्शन 4. What subsection 4 says? Subsection 4 says that without prejudice to the provisions contained in subsection 1, the creditors may apply to the judicial authority for the replacement of the resolution professional, where it has been decided in the meeting of the creditors to replace the resolution professional with a new RP for implementation of the repayment plan. Meaning thereby कि यो सबसेक्शन 4 कहता है कि क्रेडिटर्स को राइट है आरपी रिप्लेस करने का, लेकिन उसको राइट कब मिलता है? उसको राइट तभी मिलता है जब उसको क्या कहते हैं रेजिडेंट प्लान को उसने इंप्लीमेंट करना है. बिफोर दैट ही हैज नो राइट. तो अगर सेक्शन 98 सबसेक्शन 1 के अकॉर्डिंगली उसमें ऑलरेडी एक ब्लैंकेट राइट था, तो फिर 98 सबसेक्शन 4 की राइट देने की कोई जरूरत नहीं थी. तो बेसिकली व्हाट इज मिसिंग इन द सबसेक्शन 1 इज दैट कि उनके कहने का मतलब ये है कि डेटर अपॉइंटेड आरपी कैन बी चेंज बाय द डेटर, क्रेडिटर अपॉइंटेड आरपी कैन बी चेंज बाय द creditor only. So that is there. हाँ जी प्रवीण जी कर रहा हूँ. ओके, तो प्रवीण जी का फोन आया कि थोड़ा सा समराइज कर लो. तो आई एम मूविंग इट बिट फास्ट सो दैट my other speakers can have more time to deliberate on their topics. This is there. एक कंट्रोवर्सी हो रहा है कि कैन को बोरोस फाइल एन एप्लीकेशन अंडर सेक्शन 95. तो इसके बारे में भी यस और नो है. since there is a scarcity of time, I won't be discussing it in detail, but I'm just putting it before you so that later on you can look into it, because we have seen it that in the case of NBFC, especially in the northern region, that they always treat the directors as a co-borrower rather than एज ए गारंटर. तो उस केस के अंदर यस और नो में क्या है आपकी जो सिचुएशन होगी दैट यू कैन अंडरस्टैंड. ओके, अनदर प्रॉब्लम कम्स आउट टू बी दैट देयर इज नो पोर्टल फॉर द आईबीबीआई टू अपलोड द कंसर्न फॉर्म. तो उसमें आईबीबीआई ने एक इशू करा और नोटिफिकेशन किया, इस मेल पे आप उनको भेज दीजिए और कब कब अपने भेजना IP1 फॉर्म, IRP1 फॉर्म, सो डेट. तो ये एक पुट अक्रॉस जो हमारे आरपीस को काफी प्रॉब्लम आती है इसको देखने में. Okay, one of the public sector bank recruited me and asked, took the opinion ki should we go for the OTS or section 95 application after Sundar B Jivraji का judgment. तो इसको मैं किसके अंदर क्या benefit है, कैसे नुकसान है, I won't delve into detail into it. You can look into it later on. But in nutshell, these जो इसके बाद काफी डिटेल में हमने स्टडी करा था, and we gave the opinion to the that particular public sector bank also. रीच टू द कंक्लूजन ये आप पढ़ सकते हैं कि ओटीएस अगर बिलो वैल्यूएशन रिपोर्ट भी अगर आपको मिल जाए तो इट इज बेटर टू डू इट बिकॉज ऑफ टोटलिटी ऑफ ऑल द 8 and 9 points above. Yeah, non-cooperation as happened in our CRP 19(2) जो कंटेम्प्ट पिटीशन हम फाइल करते हैं, यहाँ पे भी सेम सिचुएशन है. तो रेगुलेशन 21 डील करता है इस बात को. अनदर जो एक बात मैं आपको बताना चाहूंगा कि इसके अंदर अवॉइडेंस और परफेक्ट ट्रांजैक्शन का कोई कंसेप्ट नहीं है. यू कांट फाइल एनी सच एप्लीकेशन अगेंस्ट द पर्सनल कंट्रोल पीजी. या वन थिंग मोर, इसके अंदर ऑर्डर दो तरह के आते हैं. एक डिस्चार्ज ऑर्डर 119 के अंदर, ये आप थॉरली बाद में देख लेना. You require a lot of planning, while doing this application. I don't have a time to let you know what planning you should have for filing application during CRP and all this process. Now, moot question is what the fees you get for doing all this thing here. फीस इसके अंदर बड़ी कम मिलती है. 15,000 से लेके 20, 25, 50,000 जब मैक्सिमम लाख रुपए तक पर केस की पर मंथ की फीस मिल जाती है। एंड उसके अंदर सबसे बड़ी प्रॉब्लम ये आती है कि केस थ्योरेटिकली 6 महीने का होता है और मेरे कुछ केसेस 3-3, 3.5, 3-3 साल रन कर गए। लेकिन एक इसके अंदर बेनिफिट ये है कि अगर आपको सपोज कर लो 15,000 रुपए भी या 20,000 रुपए भी एक पर्टिकुलर केस की फीस मिल गई, तो इसमें 3, 4, 5 जब मोर देन डेट घंटे होते हैं, तो वो मिला के आपकी फीस एक थोड़ा सा रिजनेबल अमाउंट बन जाता है। तो if you get any of the PG to CD cases, go for it. And in fact, IBBI has left it to the market forces. We request IR, regulator कि जैसे CRP के अंदर वो एक नोटिफिकेशन लेके हैं, similarly they should bring some notification there and also. This is all, this is a slide I am sharing with you कि हम लोगों ने कितने webinars IPA में या GIPA के साथ मिलके हम लोगों ने करे पिछले around 60 seminars करे। We do it basically on every week। और उसके बाद अगर आपको इनमें से किसी भी टॉपिक में कोई दिक्कत है, कुछ भी करना चाहें, यू कैन गो टू द यूट्यूब चैनल ऑफ आर आल्सो एंड गीपा आल्सो टू नो ऑल दिस थिंग। That's all. I cut short my everything, and since I need to give more time to my another learned speakers also. So with this note, thank you very much, and I would detail में जब PG to CD बात करेंगे after 2 sessions, then we shall talk again. Thank you. Thanks a lot. Thank you for giving me patience hearing.
Thank
Thanks
you,
a
sir.
lot.
Thank you, Manojji. We have very thankful to you for your delivering a nice guidance to our participants. I, on behalf of that, I once again thankful. And next speaker is our Dr. Tripti Rathi. She is from Symbiosis Law School, Pune, and having area of interest corporate law, banking law, insolvency and bankruptcy law, investment law, corporate governance and finance, company law, and have a vast experience in this field. So without going into detail, I'm requesting her to give share experience of in this field. Please.
Okay, I'm attaching my PPT in the chat box. Anybody wants, he can download from there. Please.
Please, Dr. Rathi. Unmute yourself.
Yes. Yeah. Good evening, sir. Good evening, Manoj sir. Good evening, all of you. Yes, today I'm going to talk on this information memorandum, EOI, and evolution metrics. Thank you, Parveen sir and Manoj sir, for giving me this opportunity. Basically, I can share this that it is a significant forum for me because you all are actually practitioners and I can say very expert in this field. So I now have to see that how I can contribute in this. So definitely I will try my best, sir, to give insights on this topics. And I'm thankful to Manoj sir also for these insights on PG to CD, which are very important for us being an academician. So yes, I will start my presentation. And yes, I can share my screen as well.
Yes, visual.
I hope my screen is visible.
Absolutely visible.
Visible.
Yes, yes.
Okay, so I said that I will try my best to give justice to these topics. That is information memorandum, expression of interest, RFRP, and request for resolution plan and evolution metrics. Okay, so yes, so as a part of Insolvency Bankruptcy Code 2016, it is one of the reform as far as our economics of our country is concerned. Because IBC talks about the resolution, IBC gives the remedy to the distressed companies, basically. So here, just a second. Yeah. So first of all, what is the meaning of information memorandum? What are the content of this information memorandum, or what is the design of this particular? What should be the design of information memorandum? And I will definitely talk about certain case laws wherein because of misrepresentation in information memorandum, how this resolution plan is affected. So first of all, what is this information memorandum? So Section 10 of Section 5 of IBC defines the term information memorandum. So, information memorandum, it is prepared by the resolution professional as per, under subsection 1 of Section 29. So, Section 29, it gives the idea of preparation of information memorandum, how it should be. So, as I have said that it has to be prepared by the resolution professional. Secondly, the form and manner which should be having the relevant information. Now, relevant information is also defined or explained in the code, and also it is mentioned as may be specified by the board. Now, here board is also defined, that is Insolvency Bankruptcy Board of India. Now, further, we have to talk or we have to focus also on CIRP regulations, regulations 36, which talk about the information memorandum. As I have said, we have to focus on design of information memorandum, which is very important. Here we have to ensure the disclaimers, certain tips, definitely how to design the information memorandum. So here, sub regulation 4, sub-regulation 1 of regulation 36, the resolution professional shall submit the information memorandum. Now here it is clearly mentioned that in electronic format to each member of the committee, the resolution professional has to submit the information memorandum. Now in this information memorandum, certain pointers should be highlighted. Now, such as it is all about the information of the corporate data, which includes the operations, financial statements. Now, to here, one more pointer, to whom we have to submit this information memorandum, I have said that to the prospective resolution applicant, and shall contain the following details of the corporate details. So, in the design of information memorandum, as I have said, all the details of corporate data includes its operations and financial statements. Here we have some practical challenges also. So I will talk about this later. Now here, this has to be submitted to the PRAs, that is prospective resolution applicants. And now in the content, this is really important, that what should be the part of this information memorandum, or what can be, what has to be there as an information memorandum. So one thing is that is the assets and liabilities of the corporate data. Next one is the latest annual financial statements, audited financial statements of the CD. Now, one of the practitioners, the way you are, that is the insolvency professionals, he clearly mentioned that we face this particular challenge, that when the company, that is the corporate data has not done this particular, or these documents are not there basically. So what can be done here? That is also one of the challenge before the resolution profession. So audited financial statement of the corporate data of last 2 financial years, and provisional financial statements of current financial year. Next is a list of creditors, in which we should mention names of creditors, then the amounts claimed by them, then the amount of their claims admitted, and the security interest. Security interest is defined under SURFACI, Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. Now, next is the particulars of debt, that is the details of debt due from. So here we are talking about the dues also from the corporate data, that has to be mentioned. Then details of guarantors has to be mentioned in the information memorandum. The names and addresses of the members, partners holding at least 1% stake in the corporate data. So here, the crucial part is that in the information memorandum, all the essential details of corporate data should be there. So such as here, we have to talk about the material litigation or ongoing investigation or proceeding, which is initiated against the corporate data by the government and any other statutory authorities. That should be mentioned in the information memorandum. Then how many number of workers, employees, and liabilities of corporate data should be mentioned in the information memorandum. Next is the company overview, including, that is the snapshot of business performance, key contracts, key investment highlights, all these details, including income tax returns, input credit of GST. And I'm sure that all these insolvency professionals are ensuring that all this information should be there in the information memorandum. Now, next is the details of business evolution. This is I can say this is really important, because here we have to talk about the background of the company, the potential of the company, the causes of collapse, the capacity of the company, because here we want the resolution, we want to save that particular company, we want to sell the assets of the company, capacity of that particular company, track record, product demand, and plus any other litigation if it is going on, we have to mention in the information memorandum. So in this, if you will see, this is the gist basically what should be there in the information memorandum. Next is sub-regulation 4 of regulation 36. It says that the resolution professional, I'm so sorry, I have to put in the slideshow. Yeah, so the resolution professional shall share the information memorandum. So here, resolution, now it is the duty of the resolution professional that the person has to share the information memorandum after receiving. Now here, it is subject to submission of undertaking from a member of the committee to the effect that such member or resolution applicant shall maintain confidentiality of the information. So here the resolution professional has to ensure that to whom he is submitting the information memorandum, that information the person has to this resolution applicant shall maintain the confidentiality. It is the concept of governance, transparency, confidentiality of the information, and shall not use such information to cause an undue gain or undue loss to itself. So here it is quite clear that what the resolution professional has to ensure with respect to this information memorandum. So it is clearly mentioned that the resolution applicant has to maintain the confidentiality of the information, and he should not or she should not use the information to gain undue advantages or undue loss as well. Now, yes, I should mention this very clearly that it has to comply with the requirements under subsection 2 of section 29 of this IBC. Now, certain case laws with respect to information memorandum, if you will see this case, Industrial Services versus Burn Standard Company Limited, in this it is clearly mentioned that the first step in inviting the resolution plan is for the resolution professional. So first step is for the resolution professional is that to prepare the information memorandum. And then they have to draft the eligibility criteria for the PRAs. Then with the approval, of course, this has to be done with the approval of the Committee of Creditors, COC, for PRAs to submit resolution plan. So the first step of the resolution plan, in inviting the resolution plan, the first step is that the RP has to prepare the information memorandum. Second, he has to draft the eligibility criteria subject to the approval of COC for the PRS to submit the resolution plan. Now here, one thing again, one thing which is very important. So eligibility criteria, now here typically would prescribe a minimum net worth or turnover or other financial parameters to be met by the PRS to be eligible to this to submit this resolution plan. So eligibility criteria, we have the provision also which talks about the eligibility criteria that has to be ensured by the resolution professional with respect to the submission of this resolution plan by this PRS. Now, next is once the PR is eligible. Now, once PR is eligible to submit the resolution plan, the IBC, it is clearly mentioned that RP giving an information memorandum and other relevant information to the PRA to help it prepare a resolution plan. Now, resolution plan, when RP invites the resolution plan, these are the necessary, I can say the conditions. So the first thing is that in IBC, it is clearly mentioned that RP has to give the IM and all the relevant information to the PRA so that on the basis of that, PRA can make the resolution plan. So this is quite clear and it is clearly mentioned in this particular case law. Next is this Bhima Lesh Bharadwaj and others versus Value Infratech Private Limited. In this case, what happened? The appellate tribunal was of view in the present case that the information. Now here, this is we have to be very careful while making the information memorandum that the information memorandum was not prepared with full and correct details of assets and liabilities of the corporate data. So that is the reason this information memorandum, this step is very crucial because it should contain all the correct, true and correct information of corporate data. So here also it is clearly mentioned that it was not prepared with full and correct details of assets and liabilities of corporate data. So RP also did not pursue the application filed under subsection 2 of section 19. Then what was the result? As a result, the committee of creditors decided to abandon the step of inviting of expression of interest for resolution plan. So that is the reason, the first step, that is the preparation of information memorandum. So the RP has to be very cautious. RP has to ensure that all the minute details are mentioned of the corporate data in the information memorandum, so that we have to, we can avoid this kinds of repercussions. So thereafter, in undue haste, the COC decided to go for liquidation of the corporate data. So the major concern was that the RP has not given or mentioned full and correct details of assets and liabilities of the corporate data, so that the COC decided to abandon. So here they have not taken the step of inviting the expression of interest for the resolution plan, and then they went for this option, that is the liquidation of the corporate data in this particular case, basically. So it found that the COC was not now here in further in this case itself, it is found that the COC was not constituted in accordance with the provisions of IBC, and CIRP was not pursued with the fairness and due diligence. Now, fairness and due diligence by the RP, it is with respect to this IM, that is information memorandum, then expression of interest, and then evolution metrics. In this three concepts, the due diligence by the RP is very important. And the resolution for liquidation of the CD was taken in a meeting with an improper voting share. So here, basically, in this particular case, three concerns have been raised, or issues were raised. So particularly one issue which I have said just now, that it is incomplete information memorandum. Secondly, the COC was not constituted according to the provisions of IBC, and again the CIRP was not perceived with the, now here, fairness and due diligence of by the RP. And next, the last issue, resolution for liquidation of the CD was taken in meeting with an improper voting share. So that means the voting share is also was decided improperly. So three things or three issues have been raised in this particular case. So majorly here I'm talking about the information memorandum. So I thought I should raise, I should mention here this particular issue. So now in next case, this is a recent case, I mean to say to a 2022 case, Kushal Limited versus Karthik Baldava. Now this is very important. In this, what happened, that after approval of the same, that is the resolution plan, the appellant filed an application before the adjudicating authority to recall its order, stating that RP in its information memorandum had misrepresented the production capacity of the corporate data. So that is a reason. So if you will read this particular case thoroughly, will actually realize that this information memorandum or preparation of information memorandum is crucial at every stage. We have to be very cautious. We should mention the disclaimers with respect to this, because if we want to avoid this kind of repercussions, especially the liquidation of corporate data or withdrawal of application. So that is the reason the information memorandum should contain true and correct information and detailed information of the corporate data. Now here, expression of interest, it is all, it is a concept, collective concept, you can say. I am expression of interest, RFRP, and this EM, that is evaluation metrics. So in this, what is the meaning of this expression of interest? Basically, it is a statement by the PRA, by a PRA, that is prospective resolution applicant. So here I have just mentioned the simple formula. I know already you all are expert, but just I am trying my best. Here, according to the CIRP regulations, the PRI, that is the prospective resolution applicant, the person has to submit the that is expression of interest for the corporate data. Now here, subject to certain prescribed conditions and undertakings, various conditions, and plus this PRA should get the access to the IM that we have already discussed, that if this PRA has to submit this expression of interest, they should have the access to the IM and relevant information of the corporate data. So the detailed process for inviting and submitting the expression of interest is mentioned in Regulation 36A of the CIRP. So here, expression of interest, one more thing I just want to show you all. So here, Form G is important when we talk about the expression of interest. So the resolution professional first has to be published this Form G. Okay, as a published particulars of invitation of expression of interest in Form G. Now, Form G you will find in the schedule of CIRP regulations. Just for your information, I'm just showing that this is the a second. Okay, can you see all of you this form? Anybody? Can you see? Okay, this is a form, basically invitation for expression of interest. So in this especially, we have to see this eligibility for resolution applicants. The eligibility mentioned 25(2)(h) of this code, that is IBC. So yeah, so here I wanted to mention that the Form G has to be published. The Form G has to be published in English language, one newspaper language is language should be English. The another one should be published in regional language. And now where, in which area, wherever the CD is having the registered office or principal office or any other location where in the opinion of the RP that the corporate data conducts the material business operations. Now it has to be published on the website, if any, of the corporate data. Then it is also mentioned very clearly that it has to be published on the website, if any, which is designated by the board for the purpose, and any other manner as may be decided by the committee. Now, what are the content of this Form G? I tried to show you all. One is the basic information, all the basic information of the corporate data, the timelines for the submitting the expression of interest, eligibility criteria. Now here, apart from section 25(2)(h), we have to talk about section 29A as well. Timelines for the CIRP starting from the submission of expression of interest and all the details of resolution professional and any other relevant information. So here, one thing, yes, it is mentioned in my slide also. Yeah, so the basically expression of interest, Form G plus detailed invitation for expression of interest. So here the eligibility criteria for the PRA, it is crucial because again, it is the one of the duty of this RP that they have to ensure that yes, the PRA is eligible to submit the resolution plan further. Then the eligibility criteria for the PRA. Next is the ineligibility norms under section 29A, which this particular section 29A. Here, I would like to mention one important point. Yes, the research is going on. Lot of debate is also going on, particularly on section 29A, because it talks about the disqualifications who cannot submit the resolution plans under this particular section 29A. So basically, there is a correlation between the Companies Act 2013 and section 29A. So as per section 29A, there are no amendments in the Companies Act 2013 and certain challenges are also there. You must be aware also that MSME is also exempted. That means section 29A is not applicable to the MSME. Okay. So, yes, coming back to the expression of interest, eligibility criteria, then ineligibility norms under section 29A. The next is basic information about the corporate data. So here an expression of interest submitted by the PRS must be unconditional. And one more thing, it is also referred as a non-refundable deposit. It is for the submission, there are no fees or no non-refundable deposit as such. That means no need to pay anything for the submission of expression of interest. Earlier it was certain charges were there. So here again the simple formula, PRA plus this expression of interest plus certain documents has to be submitted. So in the context of documents here, It means various undertakings. Undertakings means eligibility criteria undertaking by the PRA, undertakings not disqualified under section 29A of the IBC, then undertaking which notifies that RP, notify RP, it becomes now undertaking, it means that PRA will notify to the RP if becomes ineligible, and undertaking with regards to this information that it is true and correct, and the confidentiality undertaking. So all these documents has to be submitted along with expression of interest. Now, there is one of the challenge, again, I can say very important challenge before insolvency professional or resolution professional, that the due diligence or this compliance, all this particular procedure in IBC, there is a timeline, and it is clearly mentioned that within this particular timeline to finish this particular due diligence or compliance is a very difficult. So one thing here, it is clearly mentioned that once RP, so resolution professional, receives this expression of interest by this PRA. Now, in this particular scenario, RP has to conduct the due diligence. Okay. Now, here, based on the material on record or the provisional list of PRAs has to be prepared by the RP. Then due diligence plus the prospective resolution applicants is in compliance with the eligibility criteria
No,
drafted
I'm
by
sorry.
the
I'm
COC
sorry.
under section 25(2)(h) of the IBC. Yes,
Ma'am,
I should wind up. That's what somebody said. 8 seconds. I can't see anyone.
ma'am, 29A due diligence to be done at this stage or after receiving resolution plan?
One sec. I can't hear. Oh my God. Oh, stop share. Yeah. Yes, sir. You said something?
29A due diligence to be done at this stage before publishing provisional list of PRAs or after receiving resolution plans?
No, yes, sir. It is at the stage of expression of interest, sir. That is the reason I have mentioned clearly that eligibility criteria, then ineligibility under section 29, sorry, as per section 29E, that has to be submitted. And then after expression of interest, then the list of provisional list will be prepared, sir.
Okay, thank you.
Can I continue or I should stop, sir? I have not completed, by
Please
the way,
continue.
only
Please
2
continue. Please
concepts.
continue. Sorry to.
Okay, fine. Thank you. Where is the sharing option? Yes. Oh, I hope that my screen is visible to everyone.
Yes, please.
Yeah. Sorry, and thank you. So here, I was saying something. Yeah. So here, one thing that is due diligence plus PRA's compliance. PRA is in compliance with the eligibility criteria. That is 25(2)(h) of the IBC. Now here, then invite PRA who fulfill such criteria. Now, sir, here after this we invite PRA. Those who have completed or complied with this particular criteria with the approval of COC, having regard to the complexity. Now here, this is I have mentioned a particular section, complexity and scale of operations of the business of the corporate data and other conditions, which is prescribed by the board. Board is IBBI to submit the resolution plan or plans. After this, now here, RFRP comes into picture. That is process of EOI. The once you finish or we complete this process of EOI, expression of interest, receiving and considering. Once it is completed, then RP needs to start the process of requesting resolution plan. So these are the steps. One by one will go. So first I have talked about information memorandum. Second is expression of interest. Expression of interest, after that receiving, considering. When we complete this process, next is process for this requesting the resolution plan. Now that is called as RFRP. Now detailed process is given in regulation 36B of CIRP regulation. Now this is also called as a process note. Now here also the small formula. Now here what should be, what are the content? So this RFRP, as I have said, RFRP is equal to a process note. So it should contain each step in the in the process. It should detail each step of the process, mean to say, and the manner and the purposes of interaction between RP resolution professionals and the PRA, plus corresponding timelines should be there in this request for resolution plan. So resolution plan, the resolution professional, they have to ensure one, this is the simple formula for the resolution professional, that is information memorandum plus evolution metrics. I will talk about the evolution metrics plus RFRP to the PRS. So these are the things the resolution professionals have to be ensured. The RFRP should contain the timeline for submitting the resolution plans by the PRS, which is very crucial because IBC also, the important feature of IBC is also timelines. Now, here one thing to be noted, that is no fee or non-refundable deposit. For RFRP shall not require any non-refundable deposit to submit the resolution plan. So expression of interest plus RFRP is equal to non-refundable deposit. You can say in this way as well. Now, in practice, what is happening? I know you know better than me, but here I'm just trying to give you the information that in practice, especially at the stage of submitting the resolution plan, the RFRP would require a refundable bank guarantee. Now, this is very crucial that here why this bank guarantee, refundable bank guarantee or deposit, because here we are ensuring only the serious contenders who have the ability to implement the resolution plan, submit one and participate in the negotiation process. This is also called as performance security. Now, performance security, it is mentioned, performance security in literal sense, or the example of this performance security is the guarantee or the deposit from the bank subject to the approval. Now, here when you have to give the performance security, it is subject to the approval of the resolution plan as per subsection 4 of section 30 of the IBC. So, now all these, why it is clearly mentioned that the performance security or the need of performance security, why? Because to discourage people other than genuine, capable and credible PRS from participating in the process of the corporate data. Now, this is the eligibility. Now we have to talk about the eligibility criteria and qualifications of a resolution applicant. So here two sections are very important. Section 25(2)(h) plus section 29A. 29A is very, very, very crucial. Lot of discussion is going on currently also on section 29A. MSME is exempted for this particular section 29, applicability of section 29A. Now, coming to the point, that is evolution metrics. Now, regulation 21HA defines the term evolution metrics. Evolution metrics means these are the parameters to be applied and the manner of applying such parameters. So there are parameters, qualitative and quantitative parameters basically. So as approved by the committee for consideration of resolution plan. So basically when we need this evolution metrics, when we have multiple resolution plans. So to compare, basically, we need this evolution metrics. So the evolution metrics is required to be shared with the PRS along with the RFRP. So here one thing, PRA is equal to RFRP plus evolution metrics as well. Now, this evolution metrics lists the criteria on which the resolution plan will be evaluated. Now, in this, basically, the parameters are mentioned that on which the resolution plan, which is submitted by the resolution applicant, it will be evaluated by the committee of creditors. Ultimately, the committee of creditors are the very important or playing very important role in this. So the metrics set out the parameters to be applied as laid down by the committee of creditors for resolution plans being considered for approval. Now, this enables the COC to use, I have said that, to compare one resolution plan with another. So content of the, if you will see the contents of the evolution metrics, here one thing that we should avoid the generic statements that may be subjective and difficult to follow. Here I have one model evolution metrics, but one of the insolvency professionals said that if we follow this model in evolution metrics, it is not it is not a kind of, that it should not be a kind of standard or model that everywhere, every kind of sector it is applicable or where we can apply. So it is a kind of challenge that even if we have this model evolution metrics, not necessary that it is applicable to each and every sector. Okay, so here can you see my screen? Anybody from you, I request, can you see this screen? Okay, I hope you can see. So this is a model evolution matrix, which is I can say yes, which is announced by IPAI, CMAI. So here in this, it is mentioned that what are the qualitative parameters, what are the quantitative parameters. So there is one of the challenge, if you will see very clearly, it is given that experience of resolution applicant in this particular sector in which corporate data is operating. So the percentage is given, the score or range is also mentioned. In quantitative, if you mention that for the upfront payment, if will give more marks, then there is a possibility that will receive less resolution plan. So that is the reason this is one of the challenge that right now I'm not able to give all the details of this particular model because of time constraint. So here one thing I would like to mention, that though it is a model for referring that what should be the content of this evolution matrix, but still it is again one of the part that RP has to ensure that it should vary as per the sector. We should not decide one model and applicable to all the sectors, at least in this particular scenario when we talk about the insolvency and bankruptcy. So here I would like to stop and yes. So this is all about the information memorandum, expression of interest, and this evolution metrics. I hope that I could give certain, I have given certain information to all of you. Thank you, sir. Thank you, Parveen, sir. Thank you
Thank
so
you,
much.
Dr.
And thank you,
Tripathi.
participants.
Thank you, Dr. Tripathi, for your simple and detailed deliberations. Thanks a lot. And next one is our speaker, Mr. Sunny Hani Satpal. Brief about her. Hani Satpal is founder of HS Legal, advocate and consultant. She is a master in law and commerce. She is qualified company secretary and cost and management accountant as well. Satpal's practice primarily focus on commercial and corporate advisory as well as litigation. She regularly appears before the various benches of NCLT across the country, Honorable NCLAT, Honorable High Court, and Honorable Supreme Court of India. The major practice area involves of the matters including insolvency and emergency proceedings, corporate restructuring, merger and acquisition, and shareholder disputes. She also handles a wide range of corporate law matters, including contract negotiation, drafting, and review, as well as corporate governance and compliance. Along with this, she is also having wide experience in the field of legal field. And with this, I request to Mr. Hani Satpal to share his experience and views with regard to their deliberations. Please.
Thank you so much, Praveenji. Thank you so much for inviting me as well. And as I have been allotted a topic to discuss on the recent judicial pronouncements, so I'll be sharing certain recent judgments, which I'll try to remain in the period between 23 to 24. And we'll just discuss certain pronouncement, which I believe that would give some clarity on some questions which actually affect for us running the resolution process smoothly and also remove the complexities. I'll share my screen to share a small PPT that I could prepare. And if you could just confirm, Praveenji, can you see the screen?
Yes, yes.
Thank you so much, Mr. Sethi.
Yes, visually,
Yes, thank you so much. The very first slide which is opening right now is the same issue which Ms. Tripti Madam was also discussing with respect to Section 29A. And we have a recent judgment of 2023 of the Supreme Court, Honorable Supreme Court, 29th of November 23 has now decided on 2 or 3 important points where we all IPs were seeking some clarity. Now, this particular matter had traveled up to the Supreme Court because there was one of the resolution plan by the promoter which was rejected by adjudicating authority for the reason that the MSME certificate was taken after the commencement of the CIRP. Now, there are one or two more cases which I had come across where this understanding was developed by the insolvency professionals. I had actually had recently communicated to one or two, and I could understand that this has been the conception that if, or say the misconception that if a person is a promoter in the company, he is not eligible to give the expression of interest or the resolution plan of his very company, which is clarified now by the Honorable Supreme Court. 2-3 important points. I will just discuss the brief of the whole case. 2-3 important points which has been now clarified by Honorable Supreme Court. One is this: just because you are the promoter of a company doesn't make you ineligible to take the participation in the resolution process. To be ineligible, you would have to fall into the criteria of ineligibility which has been provided under Section 29A. If you had gone through Section 29A, there are prominently 3 clauses which directly hit to the promoter and the connected person. One of which is this, that the account of the resolution applicant should not be NPA, should not have given guarantee for the corporate debtor or the defaulter, and the connected person who has connected person of the resolution applicant or any person who is coming in joint or concert with the resolution applicant is falling into any of the ineligibility criteria. But suppose if there is a promoter and who's he's coming as resolution applicant, the promoter can be individual as well as some body corporate as well, because there are companies, subsidiary company, associate companies of the holding company which are undergoing CRP process. Holding company wants to come and file a resolution plan. Whether the holding company, just because its holding company is ineligible to take participation, it has been clarified by Supreme Court that no, you would have to see whether that resolution applicant as on the date of submission of the resolution plan is ineligible to submit the resolution plan. So if there is no NPA account, the promoter has, or the resolution applicant has not given guarantee for the defaulter, is not having any connected person who is falling into any of the criteria prescribed under Section 29A, the promoter would also not be an ineligible person. So as MSME has been exempted from these 3 clauses also of 29A, the Supreme Court clarified on that aspect also. When would you see, because there was a very complex question with which everyone was struggling even at the adjudicating authority level, that when a person should apply for the MSME, if suppose a promoter is applying for the MSME certificate post the commencement of the CIRP, the RPs started making the allegation that because the promoter took the MSME certificate only after commencement of the CIRP, and that's why that person should not be eligible to give the resolution plan or seek any exemption from the eligibility criteria. Supreme Court clarified that the Section 29A itself begins with the time of submission of the resolution plan. You have to see the eligibility status. So if the MSME certificate is being applied even after the commencement of the CIRP, it is not incorrect in terms of the law, and the eligibility status would be seen at the time of submission of the resolution plan. And therefore, if you see my slide in point number 3, and in fact in point number 2, I just like copy pasted from the judgment which says that the cutoff date will be the date of submission of the resolution plan to identify the eligibility status. And that also says that we certainly can look to the statement of the minister for purpose of the cutoff date, that there is no other specific provision providing for the cutoff date which submits that it should be the date of application of making the payment. Just to opine that it is initiation of CRP proceeding which is the relevant date cannot be said to reflect the correct legal date. Mr. Bassi, would you mind please keeping your mic muted? So this is one relevant judgment. There's another judgment of Honorable NCLAT, which was pronounced on, in fact, 3 days back only. That is on 21st of May 2024. Again, very interesting judgment, though if you just go by the headline of the judgment or the conclusion of the judgment, which says that we are deciding that what should be part of the CRP cost and what should not be the part of the CRP cost. So you may see that, you may think that, okay, this is something which we all know. But this judgment, if you read in detail, it is giving clarity to that how should we read section 5 subsection 13 and how should we read the regulation 31, and also that what is the role of COC with respect to their domain on the approval of the CRP cost. So this particular judgment has taken reference of the section, taken reference of the regulation, and has also taken reference of the IBBI circular. Now, what this judgment says, in this particular case, actually, it's a company, EPC company having approximately 24-25 contracts. But at the time of commencement of the CIRP, it was only at the time of commencement of the CIRP, only 7 projects were being performed. So as such, all other projects were stalled or non-operational, and only 7 projects were bringing cash or say the cash inflow in the company. Now, the issue arose because one of the subcontractor said that because I completed the project during the CIRP process, the work that I did during the CIRP to complete that project, the cost with respect to that work should be included in the CIRP cost. Now, RP had put it before the COC, and COC had decided that in COC meeting minutes, it has been recorded. It has been recorded in the COC meeting minutes that they would be giving the or including the CIRP cost only if the project is ongoing or bringing any cash inflow in the company. Secondly, if there are any vendors working in the in any of the projects, that vendor would be paid out of the cash inflow which is coming for running out of running that project. And third thing, that because those contracts are back-to-back contracts. So suppose there is the main employer is NTPC. NTPC has given the project to Sunil High Tech Engineers Limited, which has further been subcontracted. I'll just take a moment. Please. I'm so sorry. I had to attend one urgent call. So this particular COC, the COC said that even if the vendors are being paid, vendors should be paid out of the cash inflow. Now, this particular subcontractor approached the adjudicating authority, and adjudicating authority decided that this amount which he had incurred to complete the project should be included in the CIRP cost, against which the liquidator challenged before the Honorable NCLAT. Now, Honorable NCLAT has decided three important aspects. One is, no matter that your project is getting completed during the CIRP process, if first the RP as well as COC have decided not to include in the CRP cost, it will not be included in the CRP cost, because Section 5, subsection 13, read with the relevant regulation, the last clause of the regulation 31 says that any other cost relating to the going concern of the company and approved by the COC should be included in the CRP cost. So if the COC has not included in the CRP cost, it will not be part of the CRP cost. Secondly, how do you decide that a particular project is particular cost is directly related to the going concern of the company? So in this particular case, the NCLAT decided that because the project was not bringing any cash inflow in the company, though the project was completed during the CIRP, but that completed project also did not bring any cash, and it was not helping that company to keep its status of going concern. Therefore, this cost cannot be said to be directly related to keeping the company as a going concern. And therefore, and also to read with the the IBBI circular, which had come and clarified that the cost which is directly connected to the going concern of the company and has been approved by the COC can only be included in the CRP cost. Now, because the RP as well as COC during the CRP process did not include it, so no matter the subcontractor has completed the project during CRP and has incurred cost to complete that project, they should not form part of the CRP cost. So this is important because we generally would think because the project got completed by a subcontractor, he submits a bill that I did your work during the CRP process. Whatever expenses that happens during CRP process becomes CRP cost. So this is not the case. You would have to put it before the COC. Let COC approve it. You should connect it with the going concern of the company. So this recent judgment, a lengthy judgment of approximately 27-28 page, gives much clarity on this point. Next, I'll take again a recent judgment. Let's take this. Again, a very small judgment with respect to the moratorium during the liquidation period. That is dated 20th of May 24, again, just 4 days back. Now, this part is so we understand that there is one moratorium clause during liquidation process as well. I hope that we all are aware of that. That particular section is section 33, subsection 5. Now, as per that section, the liquidator cannot initiate any legal proceeding without taking permission of the adjudicating authority. And there cannot be any legal suit that can be instituted or continued during the liquidation period. So section 33, subsection 5 brings a new moratorium as soon as section 14 and section 33, subsection 5 would come into place, and that it will restrict the continuation or institution of the legal proceedings against the corporate debtor, and that it also stops the liquidator to initiate any legal proceeding without taking approval of the court.
5-7 मिनट पर ही टेक्स्ट लगे हुए कदम रख रखे मेरे सामने.
Sorry?
No, sorry.
Actually, madam, there is one question on CIRP
Yes.
cost. Can I raise that question right now?
Please.
Actually, the transportation pre-CIRP cost was paid during the CIRP period. The unit was running profitable. This was turned around from losses to profit, and the because transporter make a hue and cry and just block the gates of the factory. So we could not run the factory because of the gate blockage. And ultimately, we need to pay to the transporter under their compulsion, the compulsion, and that is allowed as the CRP cost. The unit become profitable, and we earn huge cash profit during that period, because I could not afford to close the unit because of the transporter. And we, under the compulsion, we paid to the transporter and opened the gate, and the unit was running, because there was a question of 1,000 employees at that time.
I understand, Mr. Basi. This was with respect to the pre-CRP cost, right? But you had to pay because you were to keep the company as a going concern. If these people, transporters or vendors, are not being paid, then they will not support you to run the company.
Yeah.
So because I have also faced this situation, in fact, twice or thrice, because when we advise to the RPs who are in the company, which is a going concern, I dealt with one matter in which the hospital which was running and got into CIRP process. Now there are hospitals, there are vendors. You just have to have the medicine supply non-stop. You have to have the oxygen supply non-stop. There are companies, or say the steel companies, they need to have coal supply non-stop. So this is situation which come with before so many RPs and very regularly. So what we advise to do is this: put it before the COC, because if you would also see one or two judgments of the IBBI, including one judgment that we know that there is one judgment of Mr. Khandelwal, there is one judgment in the matter of Pratibha Industries Limited.
Yes, that's right. Again, we put up before the
So,
COC, but I
yes.
think the resolution regarding approval was not passed. Passed was not taken care at that time. But we informed to the COC, and then payment was also made in installments to the transporter, that was fixed with the transporter and was paid in installments. So now actually under the due diligence exercise by the IPA, they're taking note of it and putting it to the DC, saying that this is a pre-CRP cost and all that.
So just take reference of these two judgments, because in these two judgments, IBBI has already, because if you are already facing one such query from the IBBI has dealt with this issue in 2-3 cases. If you take reference of the order of Mr. Khandelwal, you take reference of Mr. Anil Mehta's order, which is quite recent one. I think it was passed in last year is only.
Right.
In which it was discussed that how the pre-CRP cost can be treated. So you have to get the approval of the COC, your CRP cost, in which you are including the pre-CRP cost, because that is in the best interest of the company and to run the company's business without any hindrances. So the approval of the CRP cost was taken as one of the the important criteria if you want to have any exemption or IBBI से माफी चाहिए, तो this was one of the criteria or ingredient that they wanted in both of the judgments.
Right.
So yes, COC's approval would be very crucial in this case.
So one more question, at least, after the show cause notice by the DC, are we supposed to surrender all the assignments, or we need to continue the assignment till
After
the order is
issuance
passed?
of the show cause notice, you have to inform, because your AFA gets suspended.
Yeah.
So there is disclosure. So in my opinion, if suppose your name has been proposed somewhere, but you have not been yet appointed, so you just have to inform so that your new assignment, the new assignment doesn't come in your name.
Yeah, the AFA, that for new assignment it's okay. I have one personal guarantee assignment going on, so I need to apply to. I need to inform to NCLT also.
No, once if only show cause notice has come into place, your only AFA gets suspended, but the ongoing cases, you don't have to surrender from the ongoing cases.
Okay, that's right.
Yes.
Thank you very much. Thank you.
Yes, it is only that you will not be able to take new assignment.
So should I bring it to the notice of the NCLT at this moment or not?
In my opinion, it is not required at this stage, because show cause notice can result into your favor as well. And if it doesn't result into your favor, And generally, as we see, the IBBI puts in its operative part of the order that you would be informing to the COC, and let COC take the decision with respect to the ongoing process, whether they
Right.
want to continue or they don't want to continue you.
Right.
So at this stage, in my opinion, if you will not inform, it should not be taken as any non-compliance on your part.
Right. Thank you. Thank you very much.
Welcome. So, just let me. So as we were discussing this, there is I was discussing about section 33 subsection 5 and section 33 subsection 5, which is the moratorium clause under liquidation process. And the moratorium clause under liquidation process says that the new legal proceeding should not be instituted or continued against the corporate debtor, and liquidator, if want to do that, will have to take the permission. Now, I'm actually carrying two judgments on this particular point. To start with, let's take one smaller judgment on this point. I'm so sorry. I think I. So this was decided on 1st of February 2024. The question which was before the Honorable NCLAT was this, that when adjudicating authority has allowed liquidator to prosecute on behalf of corporate debtor as per section 33 subsection 5, whether liquidator is fully entitled to pursue the writ petition on behalf of the corporate debtor or not. So the short point over here is this, that the liquidator had gone to adjudicating authority, had also taken approval to initiate litigation on some against some specific party. Now that particular say the permission given by the Honorable NCLT did not say that, yes, specifically I am allowing you to initiate or to approach the Honorable High Court by way of writ petition. So when the liquidator initiated writ petition against one party, then that party had gone to the adjudicating authority and had objected on this point that there was no approval taken by the liquidator from the adjudicating authority to initiate writ petition particularly. So the Honorable NCLAT decided and said that once the permission was given to initiate legal proceeding on certain point of law against certain party, the liquidator doesn't have to go back again to take the specific permission to initiate the writ petition. So yes, requirement of taking the permission from the adjudicating authority cannot be done away with. You cannot presume that you are having the power to initiate the legal proceedings. You will always have to take the approval from the adjudicating authority. But once you have taken the approval from the adjudicating authority, to meet the cause and to exercise that cause, to which forum you would go, that will be decided by you. And for that, again and again, you will not have to go to the Honorable Adjudicating Authority. In this particular case, that is C. Rajiv Bansal versus Liquidator of ISOLux, this question has been decided. Now, one more case. This is Commissioner of State Tax Department versus Ramchandra Dalaram Chaudhary, liquidator, on 20th of May 24. So the Gujarat State Tax Department had initiated the proceedings. So this we understand. This has been now clarified in various judicial pronouncements that there is no hindrance, or there is no restraint on these tax assessment authorities to continue with their assessment process during the moratorium. So they can carry on the assessment process, but they cannot take any recovery action against the corporate debtor during the moratorium. So this applies during the CRP process as well as during the liquidation process. Now, here the Commissioner of State Tax Department of Gujarat had filed the claim. So they carried on the assessment proceeding and then they filed their claim as a secured creditor. But the liquidator had taken their claim or admitted their claim as unsecured operational debt. They had filed a secured operational debt creditor, and but the liquidator had admitted the claim as unsecured operational debt, against which there was challenge and which fight came up to the NCLAT. Now, NCLAT in this particular case had decided one thing, that Commissioner of State Tax Department, the State Tax Act does not have the pari-materia clause as the Gujarat VAT Act. Because if you remember, in the Rainbow Judgment, we know that the Gujarat VAT had a specific clause where the charge on the asset, the tax department can have the charge on the asset, and therefore they are treated as secured operational creditor, which is not the case in the Commissioner of State Tax Department. So the Honorable NCLAT first said that first thing, that there is no such clause in the State Tax Act of Gujarat as it was in Gujarat VAT Act, and therefore they could not have filed their claim as the secured creditor. And secondly, that during the moratorium period of the liquidation, they could have just filed their claim, but they could not have gone ahead with attachment of the property. They could not do any recovery proceedings. So if they had done any attachment during the moratorium process in the liquidation period, then the attachment would be illegal, and adjudicating authority had asked and had directed the department to release the attachment as a even after given the time frame, the attachment was not released, and against that order, in fact, the department had come before the NCLAT, but the Honorable NCLAT had decided that the adjudicating authority was not wrong in deciding that they could not have taken any step during the liquidation process because of the moratorium under Section 33, subsection 5. So this is the judgment with respect to the Section 33, subsection 5. Now, two judgments that I would share would be, if you just allow me to share one screen, I'll just close this particular PPT. I'll just open another one. 1 second. So this is a question which is, though has been decided in various judgments, but we would say still pending before the Honorable Supreme Court till date. So what is the position with respect to the dissenting financial creditors during the resolution process? So number of judgments which have come from the Honorable NCLAT. And to summarize what Honorable NCLAT has decided is this, that we all know the dissenting financial creditor will get minimum of the liquidation value. Now the quarrel was, how do you compute the liquidation value? With respect to the dissenting financial creditors, the computation of liquidation value, particularly if they are the secured financial creditor, then the fight is always on the computation of the liquidation value basis the security interest, or say the value of the security interest to be taken there as liquidation value. Now, various secured financial creditors who during the CRP process, when they analyze that where they are best benefited, if they dissent from the resolution plan, then they have one exclusive security interest in their name. And if they compute the liquidation value of that particular security interest that is coming much higher than the resolution plan, what is provided in the resolution plan, then they decide that, okay, let us dissent from the resolution plan. And if we dissent from the resolution plan, we can have the security interest or equivalent value of the security interest. No, this quarrel had come up to NCLAT, had gone up to Supreme Court. The question, in fact, if we see, is still pending in the Ruchi Soya case because that has now been referred to the larger bench. But because a particular journey has already been taken, a path has been crossed from the NCLAT. Let us just see that what NCLAT till date has decided in that aspect. So the very first judgment that I am taking is, I'm just taking it very short because I was told that my session would be for half an hour. So I'll just take 5 more minutes and give the important judgments, because very relevant for all those resolution professionals who are inviting the resolution plan. So one is Sidvi versus Vivek Raheja. And the question was whether distribution approved by the COC as per voting share is in contravention of section 30 subsection 2. Because if you are not, the NCLAT actually decided here one very important point, that when you read section 53 does not use the word the security owed to a secured creditor. So when you compute the liquidation value, take reference of section 53, and section 53 uses the expression debt owed to the secured creditor. So you always get the liquidation value of the debt. You do not get the liquidation value of the security interest. And therefore, to compute the liquidation value of the dissenting financial creditor, you compute the liquidation value of the debt and not of the security interest. Therefore, if a secured creditor who has dissented and says that, no, my security interest value in the liquidation would be 500 crore, and the debt, if I take the liquidation value of that, is coming only to 5 crore, I should be getting the value of the liquidation value of the security interest. So the Honorable NCLAT said that no, it is not the value of the security which has to be computed. You always have to compute the liquidation value of the whole corporate debtor, which you do, in fact, when you carry on the valuation process. The liquidation value which you have arrived at, that would be considered. Now, in the carry on judgment, which had decided on this point, that if the financial creditors which are actually bifurcated as secured and unsecured, and they may be dissenting and they may not be dissenting. I mean, there is assentment or dissentment of the resolution plan. The dissenting financial creditor had gone to the NCLAT saying that because I am dissenting, there is a discrimination. So, and also the unsecured financial creditor who is assenting and unsecured financial creditor who is dissenting, there is discrimination between these two parties and should not be. So the Honorable NCLAT here had decided that even if you look at Form H, which is a compliance form, that also categorizes unsecured financial creditor in two parts, one who is assenting, one who is dissenting. So if the resolution plan is giving, though you have to meet the mandatory criteria that you have to give the minimum liquidation value to the dissenting financial creditor, but you cannot come up to say that because I am dissenting unsecured financial creditor, I am being discriminated because unsecured financial creditor who has assented is getting more value. So this cannot be any ground to challenge the resolution plan. Another judgment, which is ICICI Bank versus BKM Industries, one of the very important judgment. I would request everyone to have a read of this judgment, which had discussed on the resolution plan distribution mechanism. As we understand that now, Section 30, subsection 4 also gives a liberty to the COC members to discuss and then to decide on the distribution mechanism. So if the COC in the COC meeting decide that the resolution, COC takes a view that we would be, whatever resolution plan has come, we will be distributing the same in terms of the debt, or say the voting share. So resolution plan will be distributed between the creditors as per their voting share. If this has been decided by the COC, COC is having the commercial wisdom, they can very well decide on the distribution mechanism. So in this judgment, the decision was taken, or the decision has been given that the COC, it is coming under the COC's domain to decide on the distribution mechanism. Now, this again is very important judgment, which give a reasoning that why liquidation value for the dissenting financial creditor should not be the security interest. If you remember, there was JP's judgment, and after that Amit Metallic's judgment of the Honorable Supreme Court, which had given contrary views to each other. So what were that contrary views? Just give me a moment. So the contrary views were this, that in the JP judgment, there is one para in which the Honorable Supreme Court had said that dissenting financial creditor either should get the security interest itself and let them take it away from the resolution plan process and let them realize the value, or they must be given equal value to the security interest. But the Amit Metallics had taken reference of the JP's judgment, but had given a different view. If you read this judgment of Honorable NCLAT, it gives a reasoning that why the dissenting financial creditor should not be given the security interest. And they had taken this reference of Regulation 37. If you know that what Section 37 is, very interesting. Section 37, sorry, I'm referring section, it's actually Regulation 37 of the CIP regulations, which says that what should all be containing in the resolution plan. That your resolution plan, sorry?
Can I ask you right now?
Sure.
Ma'am, I just want to know if how the funds will be distributed when the resolution plan is approved. It will be like one is secured creditor, others are unsecured creditors, and how proceeds of the resolution plan will be distributed amongst.
So, sir, Mr. Sethi, right?
Yes.
So, Mr. Sethi, when the resolution plan is given, resolution plan generally provides resolution applicant may come up with some proposal that to how do they want their resolution plan value be distributed with the creditors. But what we generally do, we put this particular agenda before the COC for approval of the distribution mechanism. So if the resolution plan is open about which so many RAs have started doing it, that we are giving this resolution plan value, and let COC decide that how do they want to distribute between the creditors. Put it before the COC under Section 30 subsection 4, distribution mechanism to be decided. Let COC decide that how do they want to distribute between the creditors. They may also decide for the convenience of the COC, RPs also give two formats, that if all the COC members are assenting what should be the value as per the voting share, if they want to distribute as per the security interest, what every creditor are going to get, if they want to distribute as per the voting share, what would be the distribution. So you give as per the convenience of the COC all the formulas and everything, and let's simply decide on the distribution mechanism. So to take this judgment again, this particular judgment had given clarity that why dissenting financial creditor should not be given the security interest, and the reasoning given is this, that if you read regulation 37 says that the resolution applicant should provide the measures of the revival of the corporate debtor. And in those measures, the corporate debtor, the resolution applicant can provide the corporate restructuring, may also provide for sale of any asset. So when you are giving all the authority to the resolution applicant to use the asset of the corporate debtor, in which they can also provide for sale of one or more of the assets of the company, it means that when you start the CRP process, all the security interests come into a pool, and that means that as you say in liquidation process, the creditor has the discretion either to relinquish or not to relinquish. In the CRP process, to interpret regulation 37, as soon as the CRP initiates, all the assets are relinquished or deemed to be relinquished in the resolution plan process, because you are giving all the authority to the resolution applicant to deal with the security interest. So therefore, you cannot assume that because there may be one of the secure creditor and that particular secure creditor is going to dissent, you should give that value to that security to that dissenting financial creditor. That would be totally against the very object of the IBC and the CRP process. So this judgment clarifies it, but ultimately, as we see that you can just have a look at this particular judgment of Honorable Supreme Court, DBS Bank versus Ruchi Soya. The JP and Amit Metallic's reasonings have been discussed because there are contrary views, and therefore it has been now referred to the larger bench of the Honorable Supreme Court. So if you would read this particular judgment, you may have the whole background that till date, what all has happened with respect to the treatment to the dissenting financial creditors, and how the exclusive charge would be dealt in the liquidation process. So I would request to have a reading of these two judgments. One is this DBS, and second would be the this Parana judgment as well, and I was also BKM judgment I was referring to, yes. So with this, because I do not want to just overload you with so many judgments in half an hour. So these are a few recent judgments which I thought that we can have a discussion on in half an hour. So thank you so much for the patient hearing all the participants. Yes, Praveenji.
Thanks a lot, Mr. Anish Pandey. I think we need more session from your side. Insightful derivations. And
thank you so much,
on behalf
Praveenji.
of GIPA and YAPA, very thankful to the audience, participants, and our great speakers for your valuable times. And this is knowledge sharing webinars. We are organizing every Saturday from 4 to 6 p.m. So thanks a lot for everyone. Thanks, Namaskar.
Thank you so much. Have a good evening. Thank you so much.